All right, everyone, it is noon. Want to welcome you here. I'll just introduce myself. My name is Untitled. I'm an associate professor here at the Faculty of Law, and I'd like to welcome you all to the 13th DeLloyd Guth Distinguished Lecture in History, Legal History talk. Today we have with us Dr. Barrington Walker, who I'm very delighted to have, and in a moment I'll introduce him more formally and more extensively. I just wanted to start off by acknowledging that the University of Manitoba campuses are located on the original lands of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene peoples, and on the homeland of the Métis Nation. We respect the treaties that were made on these territories. We acknowledge the harms and mistakes of the past, and we dedicate ourselves to move forward in partnership with Indigenous communities in a spirit of reconciliation and collaboration. And I think flowing from that, land acknowledgement, we also have to, in addition, recognize arising out of a colonial context, the experience of colonialism has had its impacts on so many people within Canada, throughout the Americas, and I would include within that the experience and the harms related to slavery, discrimination, segregation, and I think our speaker today is going to speak so importantly on that part of the history as well. Now, before I move towards introducing Dr. Walker, I just want to briefly take a moment to talk about our lecture series and the individual who created it and after whom it was named, Dr. DeLloyd J. Guth. Dr. Guth was our resident historian at the Faculty of Law for many years prior to his retirement in December 2018. Dr. Guth specializes in 15th and 16th century English legal history and continues to examine the connections between English and Canadian legal history in retirement. Regrettably, Dr. Guth couldn't join us today, but is looking very forward to watching the video later on and want to extend his regrets and his good wishes on this wonderful lecture. Dr. Guth started this legal history series in 2010 with the inaugural lecture delivered by then Chief Justice Beverly McLaughlin, and she was speaking at that time on Louis Riel. Since then, we've had 11 subsequent lectures, wonderful lectures, speaking on a range of topics, including Indigenous history and very specifically Métis history. And it's great, and it's with great pleasure that I now introduce to you, Lucky 13, Dr. Barrington Walker. So Dr. Walker holds a PhD in history from the University of Toronto. He is a professor of history at Wilfrid Laurier University. Prior to that, he was a professor of history at Queen's University. In his current role as Associate Vice President, he is the Senior Advisor for Equity, Diversity, and Inclusion in the Office of the Provost and VP Academic. Dr. Walker is a historian of modern Canada, and his work focuses on the histories of Black people, race, immigration, and the law. His scholarship seeks to illuminate the contours of Canadian modernity by exploring Canada's emergence as a racial state through its histories of white supremacy, slavery, colonization and immigration, segregation, and Jim Crowism. Much of his work considers how these practices were legitimized and in some cases contested by the rule of law and legal institutions. He is the author of numerous publications, and one in particular that I would highly recommend is his 2010 monograph, Race on Trial, Black Defendants in Ontario's Criminal Courts, 1858 to 1958. This was published by the U of T Press and the Osgood Society for Canadian Legal History. I could speak personally on this because I used this text, this book in recent work of mine, and it was a wonderful study that illuminated the untold history of Black defendants in Ontario's criminal courts. Now, Dr. Walker's lecture today is entitled Inchoate Citizens, Black Canadians, Law, and the Racial State. So he'll speak for about 30 to 40 minutes, followed by a question and answer period. And just to remind everyone that the lecture, including what's happening now, is being recorded, but the Q&A session that'll take place after won't be recorded. So we'll have an opportunity for any kind of conversation that you don't have to worry about being recorded afterwards. So with all of that, without further delay, please join me in welcoming Dr. Barrington Walker.
Thank you very much, Dr. Code, and thank you all for being on this call. I see some familiar faces from my years in the academy and my few trips to Manitoba. So it's great to see all of you from Manitoba and places from places far and wide. So I'm going to get right into my talk. Inchoate Citizens, Black Canadians Law in the Racial State. In 18th century Nova Scotia, in 1786, John Harris, a Black man, entered into an agreement with a white planter. Harris, the agreement read, quote, doth bind himself as a servant to be put to any plantation or farm to work to William Stone, from the date hired to the 14th of July next, to come providing the said William Stone to find him in provisions during said time. Similarly, in 1817, 14-year-old Thornton indentured himself to a farmer by the name of George Dainstadt, evidently at the behest of his mother, a widow. The terms of his indenture stipulated that the young boy was to serve his, Dainstadt's, lawful command and everywhere readily obey. In return, the young Horton was to be apprenticed as a cord wainer, receiving, quote, sufficient meat, drink, clothing, lodging, and washing, fitting for an apprentice during said term of 6 years, 4 months, and 22 days, and shall permit and allow him to attend night school 1/4 of a year in every year during said term, and provide for him paper and pens and other necessities, and pay the schoolmaster's fees. The grim reality that Black people in the age of loyalty had to turn to these sorts of arrangements speaks to the threadbare promise of freedom under the British flag during this era. In The Skin We're In, A Year of Resistance and Power, author and journalist Desmond Cole writes powerfully about a year in Black life in Canada, 2017. This was a year that was both eventful in terms of the many stories that grabbed the headlines in the midst of the era of Black Lives Matter, and yet, to my mind, it was also a year that in many respects was rather arbitrary. For had Cole focused on 2015 or 2018, he would have surely yielded similar results. In his chapter, Justice for Abdirahman, Cole recounts in grim detail the police killing of Abdirahman Abdi and its aftermath. There was, in short, no justice for Abdirahman or the Abdi family. Cole writes, quote, the Abdi family had obtained surveillance video footage from the lobby of their apartment building. The family allowed Heather Badendock, a communications worker with the nonprofit housing corporation that operates with the building, to view the footage and describe it to the media. Badendock said Abdirahman did not resist the 2 police officers who struck him in front of his residence. Quote, when Abdi is lying on the ground face down, still the constable who has been charged punches him in the head very violently, twice, and we never see Abdi move again. In response to a statement made by the Ottawa Police Association that the charges laid against Monsian had been influenced by politics, Badendock told the CBC she believed the video footage justified the charges. By the end of March, Cole tells us, Ottawa police had started a wristband campaign in Monsian's honor. I want to thank Professor Amar Code and the other faculty members at the University of Manitoba Faculty of Law and the Guth visiting lectureship in legal history. It is an honor to have been invited to this distinguished series, and it is truly an honor to have been given the opportunity to speak at such a prestigious faculty of law and alongside the caliber of speakers whom we have marshaled for this series over the years. I've been writing, teaching, and thinking about issues related to Black history, law, and the racial state for over 30 years. In this lecture, I'll reflect on some of the major themes that I have explored in past work, where I have explored the histories of Black people in Canada vis-a-vis themes of race, law, freedom, unfreedom, and the state. And secondly, I will talk about how this past work has helped me to frame my most current and of yet mostly unpublished work on citizenship, race, and space. In her brilliant work, Exalted Subjects, Sunara Tabani devotes a substantial amount of her analysis to the issue of citizenship in a settler colonial state. Tabani's work, alongside that of David Theo Goldberg, has had a profound influence on my own work and how I have thought about the relationship between citizenship law and the racial state. Tabani argues that in settler colonial states such as Canada, the constitution of the national subject to citizen is grounded in the concept of what she calls exaltation. She says, quote, providing concrete form to the national subject's humanity, exaltation furthers national formation, such the subject becomes empowered by its bonds with other subjects constituted as its compatriots, and most importantly, with the state as the aggregate of this community of belonging. Inhabiting national subject positions crystallizes the subject's sense of self and its belonging to the social world. Further, the fetishization of the national subject of citizen has enabled this subject to experience itself within the liberal fantasy of endowing power to the state, turning reality on its head. Exaltation thus organizes a modality for the subject's bonding with the state and nation. In this way, the technique enables the state to channel the abstract humanity and general goodness of its subjects, socially organized and politically identifiable subject positions prescribed by and within a field of power. The concept of exaltation then helps us think about who is uplifted, venerated, and included in this formulation of law and racial state belonging, and who is excluded, who is rendered other, and who exists outside the bonds of civil society and national, and I would say racial belonging. David Theo Goldberg similarly notes that the formation of modern states have always been inherently racial. Racial formation and state formation, in other words, were and are mutually constitutive. The modern state and its apparatuses, says Goldberg, restrict the threat, sexual and otherwise, posed by heterogeneity. It is, quote, deeply related to the thick ways in which modern states have been racially fashioned, with the ways in which modern states have predicated themselves on racial differentiation and on state-promoted and prompted racist exclusions and exploitation. Goldberg continues, quote, they have assumed themselves, falsely as a matter of fact, to be constituted upon the presumption, the insistence of homogeneous group identity, repressively embodying sameness as value, and what they have claimed to be committed to conceptually and axiologically. In this sense, homogeneity is to be viewed as heterogeneity in denial, or more deeply yet as the recognition of heterogeneity once repressed. The writings of Goldberg and Tabani can be difficult, and I mean this in the very best sense of the word, for these are texts to which I have found myself bound to return year after year over the course of my academic career, each time finding something anew. I have cited them at length, brought them to your law school because of their historically informed theorizing about race, and the state has provided this historian with a way to think more deeply and critically about his sources, historical time and space, and the histories of Black people in Canada. Their work, among others, also allows me to consider how the histories of Black people have been shaped, but certainly not reducible to racial state governance. If we return to the stories with which we began this talk, the historical and critical ground of this critical theorizing on race and the state in Canada is clear. The tales of John Harris and William Stone tell us a lot about the challenges that Black people faced in early Loyalist Nova Scotia. As scholars such as James W. St. G. Walker and Harvey M. Whitfield have written about at length and brilliantly, Upon their arrival in Nova Scotia, Black people found that they lived on the razor's edge of freedom. Many came to Nova Scotia having freed themselves for service to the British Crown during the Revolutionary War. A significant group of others were enslaved. These were the property of loyalist slave owners. These slave owners had their property, including the enslaved people whom they owned, protected by British common law as a property right. While there was no positive law of slavery in Nova Scotia as such, despite the attempts of the slave-owning class to have such laws passed, the law did offer passive support for slavery through its recognition of the right to own property and persons. Once they arrived in Nova Scotia, some slave owners continued the practice of slave owning that they had enjoyed before the Revolutionary War. Many went to court to defend their right to their chattel in a number of freedom suits. Others, sizing up the economic challenges associated with chattel slaveholding in this new context, made the decision to free their slaves, surmising that a new economic arrangement would suffice to keep white supremacy intact and Black people in a state of servitude. These newly emancipated slaves found themselves thrust into a labor market that was difficult, to put it mildly, in ways that marked the early contours of the nascent racial colonial state. Newly freed slaves found that they often had little to survive on beyond what was alienated from them during slavery, their bodies and their labor. And while independent yeoman farming on unceded indigenous land was the ideal of freedom and for full citizenship, the quote-unquote equitable land policies of the British, at least their understanding of equitable land policies during that time, meant that Black loyalists were first in line amongst Black people for land allotments, and they received smaller grants than their white counterparts and land that was of much poorer quality. This was one factor among many that prompted Black loyalists to leave Nova Scotia in 1793 for Sierra Leone, West Africa, and their desire for full freedom and full citizenship. Those who were not lucky enough to be able to disembark for the warm shores of West Africa were confronted with the prospect of how they would survive in an environment that was both racially and climatically inhospitable. In a pattern that would be repeated over the course of the next 200 years, many eked out a living on the margins of the economy, engaging in subsistence hunting and farming via land arrangements akin to the crop lien system, selling and trading. Others, such as Harris and Horton, entered into agreements with white people, some of whom were the people who had formerly enslaved them, that looked a lot like slavery itself. Some 234 years later, Abdirahman was killed and murdered, actually by police in downtown Ottawa. The brutality of this beating turned execution was one measure of Abdirahman's status as an outsider, beyond the bonds of citizenship and beyond the bonds of the racialized and effective bonds of civil society. The sorts of effective bonds that generally, but not invariably, shield white people from the most brutal, naked, and excessive manifestations of state power. What is also clear from these examples is the interrelated nature of the circumscribed nature of Black freedom, unfreedom. And what I'm referring to is the inchoate citizenship status of Black people in Canada over space and time. The Canadian state has created modes of racial state governance, which, while they don't make Black citizenship an impossibility, perpetually place it in a state of becoming, the space of a citizenship that is not yet fully realized. Scholars such as Ronaldo Walcott refers to this as the long emancipation. In the long days after emancipation, the law and the racial state proffered Black people inchoate citizenship in the context of a racial state that posited them as inchoate citizens, unworthy of full inclusion and full equality. I have argued elsewhere that the afterlife of slavery for Black people in Canada entailed the difficult and still ongoing march to full equality and a legal landscape that was simultaneously opaque and hostile. So I want to say a little bit more about that and turn to talking about what I've in my previous work called Finding Jim Crow and some of my previous work on so that's the civil law piece, the human rights piece, and then talk a little bit about my work on civil law, criminal law. So two things have shaped my work over the past few years. The first is Black people's difficult journey then from rights-bearing subjects to their fight for citizenship rights. what I have called from our property right to citizenship rights. The second is the law's mainly tacit support for anti-Black racism in Canada, or Canadian Jim Crow. Both of these were intertwined and both constituted legal, cultural, and social terrains that Black people have had to navigate in the days after slavery. As I've written elsewhere, and as others have written, the post-emancipation period was not a sharp break from slavery to freedom, but rather a continuum of unfreedoms. The period between 1850 and 1950 is instructive. In Canadian historiography, this era is generally celebrated as the Underground Railroad to human rights national story. This story forms a bedrock of some of the deepest myths that support Canadian identity. And this direct line from the safety that Canada offered slaves under the lion's paw to multiculturalism is wrapped up in notions of, quote, the triumph of citizenship, to borrow a phrase from a scholar of Asian Canadian history in a different context. But for Black Canadians, this story was not this straightforward. The era of freedom in Upper Canada or Canada West, British Columbia, and the Maritime provinces was only possible because slavery had existed here, or the slavery that had existed here was slowly extinguished, juridically smothered, and finally gone with the emancipation of slavery in the British Empire in 1833-1834. But as many other scholars have noted, in the Loyalist era and in the 19th century, the abolition of slavery did not mean the abolition of white supremacy. The memory of slavery served to curtail the citizenship rights of slavery's descendants. In my previous work, I explained the paradox lived by Black people after slavery. They were legally free, but they did not enjoy full citizenship. They lived, in essence, in a place where I've called the space between the veneer of their formal legal equality and pervasive societal inequality. The legal order tacitly supported white supremacy and the constellation of attitudes that consigned Black people to second-class citizenship, where they were unable to access the exalted citizenship reserved for white people. This tension between legal freedom and legally supported societal inequality played out in many arenas. For example, the Common Schools Act of Canada West tacitly supported school segregation through a law that gave parents the choice to open their own schools under some conditions, any 5 Negro families. But this was used to compel Black parents to keep their children out of the common schools. A Canadian version of Jim Crow also emerged by the turn of the century, and unlike its US counterpart, that was comprised of racial segregation by Black letter law for the most part. In Canada, the law legally supported the individual's right to discriminate. So, legally supported patterns of segregation endured in restaurants, pubs, hotels, and skating rinks in Canada. And Black people did engage in legal challenges to the status quo now and again, and from time to time, these challenges were moderately successful. But in the main, the general pattern held firm. Black people faced harsher and unequal justice in the courts, higher sentences, and when granted mercy, it was often done so on the basis of racialist arguments about their diminished capacity or an inherent lack of intellect or premeditation. Some Black people enjoyed economic successes. A yeoman class of farmers and the middle class of business proprietors emerged in many cities in Canada, but in the main, Black people were consigned to the lower rungs of the socioeconomic ladder. Immigration law was one area where anti-Black exclusions were overt and supported by Black letter law. Then the racial preference ladder that structured immigration policy for much of the 20th century, so roughly from about 1906 to 1967, had Black people occupying its lowest rungs. Only Black people of quote-unquote exceptional merit were allowed into the country during this time, a few workers, students, nurses, and domestics. And it was not until the immigration reforms of 1962 and again in 1967 that overt racial preferences were replaced by a putatively or presumably more neutral point system that nonetheless has been the subject of much critique. And immigration was not merely opened up due to the beneficence of the state, but due to the pressure that activists placed on it. So the insistent pressure of Black activists that Canada open its borders to people who are Black and non-white. As for the paradox of Black legal freedoms and societal unfreedom, Black Canadians, like other non-white Canadians, would have to look to human rights laws of the post-war era to address these persistent problems. Legally supported racial discrimination proved to be a much more cunning and elusive target in Canada than its US counterpart. The elusiveness of the law continues into the 21st century, the neoliberal era marked by neoliberal racism, or what some scholars have called raceless racisms, or racism without race. My latest and of yet unpublished work is about Black people's experiences of danger in Canada's urban centers, Toronto and Halifax to be exact. The era of anti-Blackness that under conditions of the neoliberal state is what interests me now. There are several issues that animate my interest in this work, in this period, and this particular conjecture of the history of law and the racial state in Canada. I'm particularly interested in how space serves as a proxy for race in this era of raceless racism, and how one of the markers of Black people's Inchoate citizenship status in this present moment is that we are deemed out of place virtually everywhere, except for carceral spaces and spaces that bear the imprint of carcerality or performance spaces under white gazes. So in conclusion, this talk is the first iteration of a chapter on history, law, Black Canadians, and Canadian critical race theory, or a collection on Canadian critical race theory. The last major book-length treatment of Canadian critical race theory was the foundational work of Dalhousie University professor Carol Aylward, written in 1999. And in this work, Aylward says, quote, "In Canada and the United States, the law has failed in its purpose of establishing justice for Black Canadians." Aylward reminds us that the legacy of slavery and racial discrimination is what plagues Canada and the United States, and that legacy is racism. This racism, and anti-Black racism in particular, I have tried to suggest in this talk, have been an integral part of Canadian state formation. Anti-Black racism in Canada, like other racisms and exclusions, has been a constitutive element of Canada's settler colonial racial state. So any reconsideration of Canadian critical race theory then will necessarily take us beyond important trials and legal decisions that dot the historical landscape and provide us with the tangible evidence that Black people did not sit acquiescently in the face of their oppression. They fought the threadbare nature of the citizenship that was offered to them and pushed the state to live up to its own rhetoric of equality. And as I have suggested here and elsewhere, Black Canadians faced a daunting landscape. The homogenizing impetuses of the state and civil society, the inchoate nature of Black citizenship, and its shaky foundation in the settler colonial racial state, and the role of the law in supporting white supremacy through a raft of legally supported exclusions. All of these created a difficult situation for Black people in Canada, a difficult situation with and in which we are still living. It also, I think, needs to come to grips with not only the long and still unfinished journey to freedom and full citizenship in the centuries after the abolition of slavery, but the ascendance, and I would say the reascendance of the sorts of cruder and vulgar racisms that are now emerging in our current landscape. Like many of us, I had once thought that these racisms were an artifact of an earlier time. Experiential knowledge grounded in my 50+ years in Canada has never allowed me to fully buy into dominant teleologies of race relations through the Jim Crow civil rights and increasingly global post-colonial struggle, post-civil rights to full citizenship, end of racism trajectory. So that kind of liberal trajectory of racial progress. I think that some historical patterns have been safely relegated, or I thought rather that some historical patterns were safely relegated to a distant past. At my previous university, I was giving a lecture once on the history of Africville at the standing invitation of a now retired colleague who taught in the Department of Geography. Before delivering the lecture, I typically would tell the students that they would have to bend their historical imaginations to fully appreciate the sorts of attitudes, values, behaviors, and mores that shaped Canadian life at an earlier time. The attitudes that shaped the white elite's decision to relocate the community of Africville, I often suggested, would be foreign to them as they had been born in the 21st century or just outside of it. Their only experiences of the country had been long after the days of official multiculture. Their only experience of the country is one, again, where the identity of a multiculture had become central to the country's official ways of knowing itself. But the last time I presented this lecture, I vividly remember telling students, perhaps somewhat pessimistically, perhaps not, that they should not have any difficulty actually understanding and in some cases even identifying with the ideas and attitudes that would be coming to them from the historical archive. It was my position that they were living through a time where vulgar racisms, what some scholars have called racial naturalism, was in a period of reascendant. That was the beginning of our beginning of our declension into a populist right that was fomenting in the darker recesses of the internet, soon to make its appearance felt in mainstream political life and civic culture. A few of the students seemed surprised by the frankness of my remarks. Others looked sad, and still others seemed to be visibly offended. We are still living in that moment, in the grips of a racial populism that few of us, at least I, didn't see coming. Secure, smug even, as we were in the belief in the inexorable forces of progress, as witnessed, for example, in the dramatic demographic changes in our major cities, rationality and enlightenment. But for the purposes of this discussion, what are the implications of this moment for thinking about themes of Black citizenship, Black freedom, and the racial state? It is clear to me that this moment challenges conventional conceptions of historical time and space. Much has changed, but much has remained the same, a condition that, drawing upon Black studies scholarship, I have called the changing same. Black people in Canada continue to fight for full freedom, full inclusion, and full humanity under the, quote, veil of slavery, or the long shadow of the era of slavery. Some will quarrel with what they see, or they will see as my reduction of the histories of Black folks in North America and Canada. But for me, it is key for thinking about Black modernity alongside the law, race, and the racial state. The material conditions of Black people, like all Black Canadians, I think have improved over time. Many of the gains of the civil rights era, the fight against racial exclusions in immigration policy, housing, and education have undoubtedly improved Black life. And much of this is due to the hard-fought legal protections that were won after World War II and enshrined in human rights codes. So I don't mean to diminish that legacy. These codes, human rights codes, not coincidentally, are part of my administrative role in EDI and shape how I think about how to go about doing this work. So again, I do want to honor that legacy. At the same time, much has remained the same. A critical race theory of Black Canada, for me, has to take this into account. What does the enduring Inchoate citizenship status of Black Canadians over time and space tell us about how race and anti-Blackness in particular have shaped modern Canada? Why do Black people who have made some of the most elegant claims on the modern Canadian state still constitute such poor rights-bearing subjects? Another way to put it might be, why in the 21st century, years after slavery, emancipation, Jim Crow, human rights, open immigration, at least on paper, and official multiculturalism, does the simple and self-evident declaration that Black Lives Matter form the basis of, or how can it form the basis of a social movement, or even be the subject of scorn, derision, and pushback? In the introduction of Until We Are Free, Reflections on Black Lives Matter, edited by BLM, Canada founders and organizers, the authors tell us that while the immediate catalyst for the founding of the movement was the murder of Trayvon Martin Brown in the United States, and the systemic inequalities that delimit the life chances of African Americans, that nonetheless, we should bear in mind that, quote, Black people in Canada are familiar with these realities. We too experience anti-Blackness across institutions. Police violence and anti-Black attitudes are realities that define the Black experience in Canada. We all remember our parents' conversations with us about racism when we were children. These conversations are repeated at dinner tables across the diaspora. Work twice as hard as your white friends to get half of what they will get. Be alert and be careful around the police. They are not your friends. To be Black means having a deep understanding of the precarity of living in societies built on anti-Blackness, thriving off the exploitation, control, and disposal of our whole selves. Thinking about the position of Black people in Canada vis-a-vis the law and the racial state also necessitates, I think, thinking beyond the state, beyond rights, and beyond the law. While my work has been grounded in that framework, I think one has to be conscious of its limits. While the challenge of attaining full citizenship and full freedom is central to my work, it will be central to the newer work I'm doing on space and racisms without race, there are material dimensions of citizenship that I believe have to be taken into account. While, as I have asserted before, there's been a resurgence of vulgar racism and anti-Black racism in the public sphere, most articulations of anti-Black racism, for the most part, in this moment anyway, remain raceless. As comedian Chris Rock sardonically put it in a recent Netflix comedy special, prices are the new Jim Crow, quote, end of quote. It may well be time for me to return to class, to start thinking about registers of Black unbelonging that are old and renewed in the present moment and beyond the reach of the law, with the exception of a serious conversation about reparations and reparative justice, in addition to decolonization. Ryerson or ex-university sociologist and critical race theorist Edward Galabuzzi famously coined the term economic apartheid to capture this intersection of materiality and rights. And this is where the abstract notion of rights and citizenship meet the harsh limits of materiality. The human rights framework that we have pursued with vigor for the past 70 plus years now has met with, at best, limited success in the face of an insurgent barrage of attacks. It is also, I'm starting to believe, of limited utility in addressing historic and systemic inequality, nor does it or can it adequately address the racial wealth gap that is a legacy of slavery and colonization. Thank you very much.
I want to take a moment to thank you, Dr. Walker, for this lovely talk. A lot to digest over thinking about the long history of Black uncitizenship. I'm particularly looking forward to your future trajectories and what you mentioned there about your future work in updating CRT and thinking about that in the Canadian context. I'm especially looking forward to that. So on behalf of everyone and everyone to join me, I'd like to thank you for this talk. So thank you so much.
Thank you all for having me. Thank you very much.